Yes, and that's the key word, modernization, and I think that's the key word for the whole conference, because in the 19th century took place very deep transformations of each and every country. We are analyzing it, and now I want to turn to Moldova and Wallachia. These are preceding states of the present day Romania, and we will start with the so-called Fanariot codification. This is very interesting because practically in those two states, Moldova and Wallachia, first, let's call it modern codes are adapted very early in comparison to any other states. For example, Serbia had a civil code from 1844, but you can see the years on the slide that we are talking about codes from 1817, 1818, which were the first codes, modern codes in this region. So we can state that these codes belong to a first wave of codification, at least in this part of Europe. But we have to check also the context of these codifications, because if we state the international status of those two states, we can say that they actually are under Ottoman control, and a little bit later also under Ottoman control and under Russian protectorate. And these influences are present during this whole period which we are talking about, because this is the period when dozens of Russian and Turkish wars took place, and these two states were at least affected by those wars. And for example, the last rulers, Fanariot rulers, I will explain immediately the concept. The last Fanariot rulers were nominated by the Ottoman Empire right after such war between Russia and Turkey. And actually this marks the end of a historical period in the case of the two states, Moldova and Wallachia. What means Fanariot? It means that these are princes nominated by the Sultan from the Greek high officials coming from the Istanbul district of Fener. So this is the origin of the name Fanariot. And practically the Sultan nominated for a certain period these princes used to obtain some money, because they in many cases paid for the job, the function, and this is a period of instability, corruption, and in many interesting way, it is also a period of certain modernization, because these Greek princes were educated people, speaking several languages, knowing the Eastern and Western cultural sphere as well, because in many cases these princes were before the dragomans of the Sultan, interpreters of the Sultan, many cases acting as spies and so on. So actually these were educated people rooted in at least two cultural spheres. And they also, beside that, they wanted to obtain money from the princelyhood. They also initiated some reforms, and for example, we can see those two last Fanariot princes. One is Ioan Caragia, and other is Scarlat Kalimach. Those were the last Fanariot princes of these two states. And the black and white picture shows Kalimach, the ruler of Moldova, who gave the first civil code in this country in 1817. 1817, which is very interesting. This is also, we can call it a legal transplant, but a multimodal legal transplant, because it is rooted also in the local tradition, very much in Byzantine law, but also it used the Austrian civil code as a model. Why? Because the enlightened prince invited Saxon, a German from Transylvania, who studied in Vienna, Christian Flechtenmacher, who actually played an important role in drafting that code. And that code of 1817, it was drafted in Greek. It was drafted in Greek. It was a text of Greek language and translated only later into Romanian, actually. And this lawyer, Christian Flechtenmacher, used the scientific work of Franz von Seiler, who is one of the main actors of the Austrian codification. And this is a classical civil code focusing only on one branch of law. The other code, the Karadzsa Code, also contained rules on criminal law and procedure, so that's a little bit much more related to the previous period. But also it was a tool of modernization, because in the preamble of this code, it was stated that the uncertainty, the lack of unitarity of jurisprudence and so on are the reasons for this codification. So we have two codes, early codes, which were seen and perceived as a first step of modernization of private law. And what happened later? Later, actually, intellectual movement started, and this is called, from the 1844 events later, even for the preceding period, it's called Pashoptism. That means 48ism. 48ism, because it was an intellectual movement which gave rise to the events in 1848, and even had influence later. Because if we want to see what happened in 1948, it's I don't know, it's not a huge effect on private law. In Moldova, there was a petition. That time ruler actually asked to the petitioners to present what they want, and later it was repression and the exile of the petitioners. That was actually the revolution, and in July, Russian troops entered Moldova. In Wallachia, real revolution took place for several months, but also first an Ottoman army and later the Russian army entered the country, and practically the revolution was crushed. So there was no real time to think about the reform of private law, of civil law. But very important in this movement of 48ism and the petitionary or revolutionary events participated several persons which later played a key role in codification. One of them, it was the first prince of the unified two countries. It's Alexandru Ioan Cuza, who was elected in the both states. He elected the same person, and this personal union gave rise to the unification of the two states. And this person was participant of the revolutionary movement from 1848, And this person is who gave a common code for the two states in 1864. And actually, my principal topic of today's presentation is the story of this 1864 civil code, which is based on the French model, and practically this transplant, this adaptation of the French code is based on the idea, also on the idea of modernization and the ideals of the 48ism, this intellectual movement. And what we can say about this code? It was in force 146 years. So 146 years. So we can say that this code was a real success. But actually, and this is a point of view not really analyzed, and this is also a legitimate point of view, that organically accepting a legal transplant is an uneasy task. And this was the case of Romania, where this code was accepted voluntarily. It was not the Napoleonic army who brought the code, but the state itself opted to this code. The culture in general and the legal culture it was dominated by Francophilia. So it was very rooted in the culture in general and legal culture to have a positive image about French institutions. And the Napoleonic Code had enormous reputation. And practically that was one of the reasons the state opted for the Napoleonic Code. The defining doctrine of 48ism called for modernization. The ruler started to learn law in France, did not obtain a degree, but had some studies of French law, and also it was a great admirer of Napoleon III. You can see even the resemblance on those images. So actually, everything seemed to be in favor of a transplant, adapting the French code into that society, and that was not an easy task in reality. And I will summarize the arguments, the pros and cons, and I will start with the cons. I will have 8 arguments against the transplant and 8 arguments which underline the transplant to have a balance in this dispute, which was a really huge intellectual dispute at that period. So let's start with the critique of the transplant, of the adoption of the French code. First of all, the first critique, it was based on the idea that the local legal culture did not have the resources to create its own legal reform, and this was actually perceived as a source of frustration, and legal imperialism manifested from within, because it was voluntarily accepted, this code, and actually this code was perceived as a mistake because voluntarily we accepted something like legal imperialism. The second argument against the code, it was drafted very fast. It was drafted very fast, actually in 6 weeks. Of course, there were earlier preparatory works, but the prince, Alexandru Ioan Cuza, actually wanted a reform agenda. The conservative majority in the parliament was against it. So he made a coup d'etat and practically, without the parliament, adopted the civil code. No parliament was functional at that moment, and it was drafted in 6 weeks. So according to the critiques, it was the highest symbol of superficiality, irrationality, extreme dependence on the French model, and actually a lack of respect of the autochthonous legal regulations and culture. Third, it is related to also the adaptation of this model. It was in the terms of the contemporaries or a little bit later generation, it was considered a simple translation, a faithful translation of the French code, or slavish translation of the French code, a complete copy of the French code, imitation of the French code, reproduction of the French code. So we can see that it caused frustration, this legal transplant. It was not so smooth. Also it was against this code, the Orthodox Church. The French code is secular, and the contemporary society in that part of Europe, it was deeply religious. And for example, if marriage, it was transformed something like a contract between a state officer and practically the Orthodox Church raised against these kind of transformations. And 1866, the Constitution reintroduced actually the religious blessing of the marriage as a mandatory element after the civil marriage, but it was a must to go to the church in this sense. Fifth, code was perceived as a foreign body towards the local realities. And we don't have much research, and that research is not possible anymore, but we have sporadic data that the code, it was not applied in rural areas. All the customary type law prevailed. The local rural people doesn't accept it as its own code just very, very late in the 20th century, probably. And the intellectuals also reacted to this kind of legal transplant in a sense that they have constructed actually a philosophy regarding the repudiation of this way of modernization through a legal transplant or taking outside models. It is called the theory of forms without substance. The forms is the Western type legislation, for example, and the substance is the local reality, which is totally different from the form adopted. And this was a general critique of how the modernization took place in a lot of regions, applicable in a lot of regions. Another critique, it is for unjustified acceptance of the foreign model, even in the cases where the local law would be a better option. So it's a foreign model adapted there was no time for that. Without research of the local customary law and acceptance of the local customary law where it is fit to be applied even in modern cases. And the seventh critique, it was seen also for the future. If that Romania took the French code, that means that it is something which is for the future, and it is something, a foreign body, which is limiting the further development of the local legal culture. And eight, practically, it is also a critique with literary force. It was said that the massive legal transplant, because in this period we are not talking about just about the civil code, but constitution is from Belgian model and so on and so on. It produced a shock, and the shock of this legal transplant, it is expressed by terms like total misjudgment, blindness, fabrication of laws, and perpetual lie, illusion. So we can see again the shock of the adoption of a foreign law in a certain cultural context. On the other hand, we can state 8 examples which underline the positive side of the legal transplant. I will be very fast. And a clear manifestation of autonomy against the Ottoman rulers. In reality, it is not a simple translation, because some texts were eliminated, some texts modified. For 45 articles, it was used the Pisanelli Code as a model, so on. So it's not just a simple translation, other elements as well. Third, legal transplant is something necessary because modernization didn't have a fast internal path. Organic development needs time, and at that moment the time was lacking. So this adoption of the foreign law was the fastest way to pursue the goal of modernization. Fourth, practically the transplanted foreign law and the local realities influenced each other. Actually, the law was interpreted according to local realities, and so there is a mutual influence, and this led to an original adaptation. This is a theory of original adaptation of the code. And also another theoretician or thinker or philosopher elaborated a theory which underlined the necessity of absorption of a foreign law. It was the theory of synchronicity of civilizations, which meant that modernization and Europeanization practically it was necessity justifying revolutionary inorganic modernization. And six, the capacity of the Romanian legal culture to assimilate the French code. It was also an argument. The seventh argument can be that due to the application in decades and 1.5 century practically in final, this foreign body of law became a Romanian law. And the eighth and last argument in favor of the legal transplant is that absorbing a foreign law, it is not a isolated Romanian story. This happened in many other states, so there is nothing to be ashamed of adapting foreign code because other states did so. And as a conclusion, both arguments are true, both sets of arguments are true in their own way, and underline that the legal transplant is not an easy issue, and the terms used, which I cited, underline also the fact that it was a cultural shock adopting such a huge amount of foreign legislation and the civil code between this mass of foreign regulation adapted to modernization goals. And the second set of argument in favor of absorbing the foreign law, it has also psychological background. If both points of view are in some way true, for accepting one person and the human mind is functioning in this way must accentuate the positive side, and that can lead to acceptance despite the cultural upheaval. So 48ism has a large history, and unorganic modernization is one of them. Maybe in some more fortunate parts of Europe, there was a lot more organic element in development, but practically the 19th century changes are so fundamental that maybe none of the states analyzed today have a totally organic development, which was impossible in the time of so deep changes. Thank you very much.